ask and answer the board.
While you're sitting in the car and he's having trouble remembering details, why don't you just share them with him?
Like I said earlier, my goal here is to get his statement for that day of his recollection so that I can compare it as part of the investigative process. We actually have a team of investigators that are working this case. We're discussing it daily. We're going back and we're discussing differences. We want to see those differences so we can use that in the investigation to determine our path and what our decisions are going to be.
But when you've reviewed his prior statements and he can't see them, then he's looking to you to fill in the gaps. That's human nature.
Objection to speculation, Judge.
Let's go ahead and... it's suspended.
Thank you. At page 4, you ask him, is this where Mr. Arbery went for the door?
Yes, sir.
And you're telling him, as you were coming in reverse.
Again, I'm not telling him. The transcripts, both of those quotes of what I said are questions. The first one, okay, is this where he went for the door, question mark? Mr. Bryan says yes. And then I respond, okay, are you coming in reverse? It's a question. Again, it goes back to the information he's already provided, and I'm just helping the narration from what he's already told me so that I can be sure that I understand, which is also in the question format, giving him the opportunity to respond if I've misunderstood it.
And while Mr. Bryan is talking to you, your phone rings during the video, does it not?
I believe hearing my phone ring somewhere there. I think so.
It unfortunately interrupts Mr. Bryan at an important part of your reenactment.
When my phone rang, it did not ring continuously until it went to voicemail. My recollection is that I silenced it once it started ringing.
But Mr. Bryan corrects you in the actual audio of this video. He says, I might have been in drive by then, as opposed to being in reverse, as you testified to. You don't recall him saying that?
I don't recall. I recall him unsure at the exact time that he believed Mr. Arbery reached for the door. It was more of it happened quickly, and it either happened while I was in reverse or after I'd gone into drive. It was more of just difficult in recalling the exact moment because of how quickly it occurred.
And Mr. Bryan added, which you did not mention today, I wasn't looking back there at him.
That's right. But again, I was paraphrasing the statement that Mr. Bryan gave me.
He was trying to figure out where Mr. Arbery was going and get out of here. That's what he told you.
That's correct. Right before he continued to chase Mr. Arbery down home the road.
Now, in the video, we see you pulling up by the ditch at a driveway where he's angled. You remember that?
Yes, that was before. Actually, that's right the same time frame. That's correct.
Now, when you're driving the car, when you back up, you're not backing up at the angle that Mr. Bryan is reported pulling in. You're not backing up the angle that you pulled in. You're backing up at an angle more towards Mr. Arbery.
I'm backing up at the direction of Mr. Bryan.
Where did Mr. Bryan tell you that he backed straight up? Where in that transcript does he tell you that?
He doesn't tell me that specifically, nor does he correct it the way that I'm doing it at that time.
Because maybe at that time Mr. Arbery doesn't understand that might be important.
Mr. Arbery?
Mr. Bryan.
Objection to speculation about what Mr. Bryan understood at that time, John.
Because you still haven't explained to Mr. Bryan that you're looking at whether there's an aggravated assault.
Sustained. Was there a question there?
There is. When you're going through this part of this with Mr. Bryan, you have not told him that you're looking at an aggravated assault.
At this point in time, I'm still looking at the case as a whole and what his involvement was. I wouldn't even say that specifically at this time I was thinking about aggravated assault.
Okay. So neither you nor Mr. Bryan know that that angle has any actual importance at the time you're making this video.
Objection to speculation about what Mr. Bryan knew at that time, Your Honor.
I'll rephrase it. You weren't deliberately trying to mislead Mr. Bryan when you angled, when you reversed in the way that you weren't deliberately trying to mislead him. It didn't occur to you at that time that it mattered.
I did not deliberately mislead Mr. Bryan at any time. The angle, the exact angle of how Mr. Bryan backed up, again, he did not correct what I did. And so that was the best representation of what I have as to what happened that day.
Now, as in the video, you show Mr. Bryan pulling up ahead. After the backing up, you show him pulling ahead. But in your testimony this morning, you didn't talk about the speed at which Mr. Bryan was moving.
Okay.
Mr. Bryan told you that that moment when he pulls away is the fastest that he's traveling during this entire incident, doesn't he?
Yes, sir.
Okay. But you didn't mention that.
Again, I didn't mention that. It was a paraphrase of what Mr. Bryan told me during that reenactment.
All right. Now, I believe you testified about Mr. Bryan backing up again, this time when he's driven past Holmes, correct?
Yes, sir. That's correct.
But when he's backing up, he's not backing up at Mr. Arbery, is he?
No, sir. Not to my knowledge.
Because Mr. Arbery's going up the other street.
I don't know the exact time that Mr. Arbery would have gone up the other street in relation to when Mr. Bryan was backing up.
I'm going to get this right before this trial is over. This little squiggle here, you see that?
Yes, sir.
That's pretty important in this case, isn't it?
Objection, Judge.
I'll rephrase it.
Relevance about what Agent Seacrest.
I'll rephrase it. In the entire interview you conducted with Mr. Bryan, did you ever ask him about Matt Albenzi?
Not to my recollection.
As far as your entire interview with Mr. Bryan has no idea what Mr. Albenzi is.
As far as I know.
But Mr. Arbery knows where Mr. Albenzi is.
Objection to what Mr. Arbery knew, Your Honor.
I'll rephrase.
Stay.
In your course of your investigation, you discovered that Mr. Arbery had run out of 220 Satilla,
That's correct.
the English residence,
Yes, sir.
and run down toward Mr. Bryan's residence.
That's correct. Well, towards, in that direction. Yes, sir.
And Mr. Bryan's got the music playing out front, right?
Yes, sir.
So he can't see or hear. He has no idea Mr. Albenzi's down there.
Objection to speculation about what Mr. Bryan knew.
Stay.
Do you have any reason to believe that Mr. Bryan was aware of Mr. Albenzi's presence out there?
Whether Mr. Bryan knew that Mr. Albenzi...
Yeah.
I don't know that Mr. Albenzi was still standing out there at that point in time.
But he had been there only minutes before.
He had been there at the time that Mr. Albenzi made the phone call to the non-emergency line. That's correct.
And that would explain why Mr. Arbery turns up the other street.
Objection to speculation about why the victim did what he did.
But Mr. Bryan doesn't know any of that, does he?
Objection to speculation about what Mr. Bryan knew.
Mr. Bryan doesn't tell you he's aware of that.
That's correct.
He tells you he's surprised that Mr. Arbery turns up Holmes.
Is that in the transcript?
I believe it is. But I'm not going to go look for the reference now. But you can.
Yeah. recess.
All right, for adjourned.
All right, while they take a break, we're going to take a break. We'll be right back on the other side. Our continuing live coverage in 2 trials, one in Minnesota, one in Georgia, here on Court TV Live.
Tonight on Closing Arguments, everything you may have missed from the killing of AHUMAD Arbery murder trial as the state continues building their case against the McMichaels and Roddy Bryant. We'll break down the biggest moments from today's testimony. Plus, we get you ready for Monday's Closing Arguments and the Kenosha protest murder trial. What key points will each side need to make for this jury? We'll catch you up on every key moment as the trial reaches its end.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central, only on Court TV.
Hi, my name is Tony Cooper, and I'm going to tell you about exciting Medicare Advantage plans that can provide broad coverage and still may save you money on monthly premiums and prescription drugs. With Original Medicare, you're covered for hospital stays and doctor office visits, but you have to meet a deductible for each, and then you're still responsible for 20% of the cost. Next, let's look at a Medicare supplement plan. As you can see, they cover the same things as Original Medicare, and they also cover your Medicare deductibles and coinsurance. But they often have higher monthly premiums and no prescription drug coverage. Now, let's take a look at Humana's Medicare Advantage plans. With a Humana Medicare Advantage plan, hospital stays, doctor office visits, and your Original Medicare deductibles are covered. And of course, most Humana Medicare Advantage plans include prescription drug coverage. In fact, in 2020, Humana Medicare Advantage prescription drug plan members saved an estimated $8,400 on average on their prescription cost. Most Humana Medicare Advantage plans include a Silver Sneakers fitness program at no extra cost. Dental, vision, and hearing coverage is included with most Humana Medicare Advantage plans. And you get telehealth coverage with a $0 copay. You get all of this for as low as a $0 monthly plan premium in many areas. And your doctor and hospital may already be a part of Humana's large network. If you want the facts, call right now for the free decision guide from Humana. There is no obligation, so call the number on your screen right now to see if your doctor is in our network, to find out if you could save on your prescriptions, and to get our free decision guide. Humana, a more human way to healthcare.
With so many mesothelioma lawyers on television, how do you choose the right firm for you and your family? I'm John Morgan of Morgan & Morgan, and here's my advice to you. Do your research. Results matter. Reputation matters. As America's largest injury firm, we have more offices, more lawyers, and more caring staff members than any other injury firm in the world. Last year alone, our team answered over 2 million of your calls and recovered over $1 billion for our clients. $30 billion was set aside for mesothelioma victims like you. If you've been diagnosed with mesothelioma, we'll come to you within 24 hours so our team can get to work right away. Wherever you are, whenever you want. Our goal is to get you as much as you deserve. Call us now. There's only one Morgan & Morgan.
Call 1-800-512-7300. That's 1-800-512-7300.
The word victim is a loaded word. And I think alleged victim is a cousin to it.
You're carrying it concealed, are you not?
That is correct.
It's unlawful for you to carry it concealed. Is that not true?
Unlawful?
There was people right there.
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
Is that video edited?
No, I have not edited it, but it has been put together at the right time, the timing.
Who did that?
I did that.
Welcome back to Court TV Live. I'm Ashley Wilcott. Happy you're with us. We want to stay in Wisconsin. I may have inadvertently said the wrong state, but Wisconsin is where the prosecution and defense have rested their case in the trial against Kyle Rittenhouse. Now, closing arguments are set to begin on Monday before the jury must decide the fate of the now 18-year-old. Both sides used video evidence as a key portion of their case. But one particular testimony seemed to have had the most impact on this trial and could be problematic to jurors. That is, of the shooting survivor, Gage Grosskreutz. He was expected to be the state's star witness, but during cross-examination, the defense was able to call him out on several inconsistencies, and they even got him to admit a crushing blow to the state's case.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
And now he's taking it all back. In an interview with CNN last night, Grosskreutz explains why the narrative may have gotten twisted.
I think it's important to note, though, that specifically during cross, and if there is a skilled attorney, they're able to present questions to help support their narrative. That's their job. And with one of the exhibits that Attorney Sharofsky had introduced, there's a photo of me with my gun pointed towards the defendant, either just after or right during. He had shot me in my right arm. I think it's important to note, though, that the physiology of my wound would be inconsistent with somebody being shot with their arm and, we'll say, the traditional way that you would point a gun at somebody or something. The only way that I could have sustained the injury that I have is if I had been shot with my arms up. I think that, again, in the still photos, it certainly looks like it, but never intentionally. You have to understand that following that gunshot, I had no use of my arm. I wasn't able to move anything in my right arm.
Joining me now to talk about this, I have former criminal defense attorney Kirk Nurmi, as well as Melba Pearson, former homicide prosecutor. Thank you both for being with us. Kirk, let me start with you, if I could. What are your takeaways, or what do you think when you see this interview? Anderson Cooper of CNN had this interview with this witness.
You know, I wonder, I go back to the state's preparation for this case. We've all seen that the state made promises that maybe they haven't delivered on with the evidence. Promises an opening. And we see now we have this star witness. You're right. The survivor, the man who Mr. Rittenhouse shot at and survived, should be the most prepared witness. He is the star. He is the centerpiece. And we have him claiming confusion over cross-examination. If I was a prosecutor in this case, I would have had him in my office as often as possible, and I would have had someone else in my office cross-examining him over and over again so these things wouldn't happen. I would have had him prepared so a mistake like this could not happen. And clearly the state seems to have fumbled the ball in terms of preparation.
All right, Melba, tell us your thoughts, and also add to that whether or not you think that this is crucial to the defense's case and possible success depending on a jury verdict.
Unfortunately, I do think this is quite crucial to the defense's theory of the case that the defendant acted in self-defense. I definitely have to agree with my fellow guest and co-counsel that, you know, the preparation is key. And when I tried homicide cases, you know, you had to prepare your witness every single different way for any potential question that may come up. Now, the other thing that could have been done to rehabilitate the witness was to maybe bring on, as a part of the rebuttal case, a medical expert, whether it be a doctor or surgeon, to explain that the angle of the wound would have shown that he could not have been an active threat at that moment. But unfortunately, we are where we are. Both sides have rested. Closing arguments are going to begin on Monday. And now all the prosecution can do is really argue that the defendant's actions on that day were not reasonable, that he was not, you know, in fear or had any reason to attack the people and shoot the people and kill the people the way that he did on that evening.
All right. What I'd like to do now is listen to a little bit more of that interview with CNN, specifically when he did talk about Kyle's testimony. And we've seen Kyle breaking down on the stand when he testified. Let's see what this victim survivor had to say.
Specifically to the defendant's testimony, I can't say that I was, one, particularly impressed nor convinced. To me, it seemed like a child being upset because they were caught, not upset because of what they had done wrong.
Upset because they're caught, not upset because of what happened. Kirk, what do you think? And did you believe Kyle Rittenhouse when he broke down on the stand? There's a lot of divisiveness over he was faking it versus it was authentic, and he really was breaking down on the stand.
Right. I believe it was genuine, but the question really relies around what the source of it is. I mean, a lot of PTD experts put together what this alleged victim had to say, put that aside, I should say. And you talk to experts in PTSD, and they will tell you that even those who commit intentional acts of murder can have these kind of breakdowns, can have this sort of connection to PTSD. So could it have been because he was feared for his life? Yes, this breakdown. Could it have been because he was starting to understand the gravity of the situation that was before him? His mother's out in the crowd. He's on trial for first-degree murder, and he's killed someone. I think that's more likely, especially if we talk about later on in the cross-examination. I felt like the confidence that was in his face before lunch began to drain after lunch, and the gravity of the situation might have been hitting him, and this might have been the focal point of that hitting him.
And Melba, do you think that his demeanor and the breakdown, I call it a breakdown on the stand, do you think that that's going to be the subject of either of the closing arguments that we anticipate coming Monday morning?
Listen, if I was the prosecutor in the case, I would absolutely make it the subject and take away some of the potential impact. Because to be quite honest, when I looked at the footage, I didn't see one tear fall out of his eyes. I saw a lot of boo-hoo-hooing, but I didn't actually see tears rolling down his face to really indicate that he was truly upset about what was going on. And if you think about, some of this, the jury may not have gotten to hear, but, he was out partying, hanging out with Proud Boys, flashing white power symbols and all of that. So granted, the jury may not have the benefit of knowing that, but I don't really think if there were any tears, there were crocodile tears. They were not genuine. And I would certainly, as the prosecutor, argue that he was not crying on that day. He had no fear, and that he came to Wisconsin with the express purpose of doing harm to people that were protesting in favor of social justice.
Right. And Melba, to your point, the things that we know as the public versus what's being introduced as evidence to the jury, including pictures in a bar where he's wearing that shirt and having drinks and being supported after all of this happened, I agree with you, does make a difference. We expect those closing arguments to be 2.5 hours each side beginning Monday morning. Now, I would appreciate you all standing by because I think we're going back to, actually, so I'm just going to fill everyone in. It did look like they were going back to court in Brunswick, and this is the case against the McMichael father's son. Travis and Gregory is the father, and Travis is the son. And then also the third defendant, Roddy Bryan, but they are not going back to court. They were going back to court, and then they didn't go back to court. So we're going to keep you posted. I may have to interrupt our discussion, but I want to stay here. I want to listen to one more piece of the CNN interview, again by Anderson Cooper, of the survivor of the shooting. 3 people shot by Kyle Rittenhouse, 2 deceased, 1 survived. He did testify. Let's hear what else he had to tell CNN after he testified in court.
So I had first seen the defendant earlier in the night, but for our last encounter, I had heard several gunshots and people starting to yell medic. So naturally I went towards the gunshots looking for a potential patient or victim. And then Mr. Rittenhouse, the defendant, was running northbound up Sheridan. And there was just something that had stuck out about him. I had a conversation with Ryan Balch earlier I didn't have a conversation with Ryan Balch, but I had overheard a conversation that Ryan Balch was having about the police and these quote-unquote militia members working together pushing demonstrators and protesters down Sheridan. So all of these things combined, the defendant stuck out to me. And so I went next to him and I asked him who was shot. And he had told me that he was going to the police and he didn't do anything, which naturally raised suspicion in my mind. And then as these next events unfolded, there was a group of people moving towards the defendant. And unfortunately, then the defendant shot twice at an unknown individual, shot again, killing Mr. Huber in front of me, and then with my hands up, pointed his weapon at me, re-racked his gun, and then shot me.
All right, Kirk, I'd like to ask you, knowing that you did represent Jodi Arias, the name really heard around the nation, so to speak, what is your expertise or opinion about why, when you see an individual testifying and answering questions, they may come across as one way with one version, and then when they're interviewed by someone, it sounds different, looks different, and it may be a little different?
You know, I think there's an extra tension that comes. I've never got to sit in the witness chair, Ashley, but, you know, I think there's an extra tension that comes with that. And we heard him reference earlier, you know, a skilled attorney kind of tricked me, that sort of thing. I don't think necessarily that's the case, but, you know, he was maybe more comfortable in the interview. It was his choosing. He got to answer the questions in his way without being restrained. And in court, he was restrained by the attorneys and the law and probably felt more nervous. And maybe, quite frankly, the world was watching as opposed to less people watching CNN. It was on his terms, not the court's.
Right. And I didn't mean to interrupt you, but I also wonder, anytime that you testify as a witness, if you walk away from it and you rethink the questions and your answers and think, wait a minute, I should have said that, or this may have made more sense. So you two are both going to stay with me. I understand now that court has resumed in Brunswick, Georgia. Let's take you back to the courtroom live.
Let anybody talk about it in your presence of hearing. Don't go picking up newspapers. Don't go looking at social media. If you're out and about over the weekend and you are around people that are talking about the case or want to talk about the case, you need to walk away. You need to make sure that that doesn't happen. And if it does, you need to go ahead and notify the court when you return on Monday. Does everybody understand the court's instructions? Any nods from everybody? All right. With that, thank you for the week. Thank you for participating in this case with us here in the Superior Court of Glenn County. I appreciate your time, and I appreciate your attention. We'll see you Monday morning at 9 o'clock. Thank you.
All right, for sure.
All right, and I've asked if we can stay in this courtroom, and here's the reason. The jury's been excused for the day. They'll come back Monday morning for trial to resume. No more trial today. But often at the end of the day, that's the opportunity that the attorneys to have to make any motions, argue any motions, and Attorney Goff certainly is one who's been pretty vocal with his motions. So I want us to just stand by and see, after the jury's excused, whether or not there are any motions or out of the jury discussions that need to be had today.
Anything from the state before we recess?
Nothing from the state.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Ronnie Bryan?
No, Your Honor.
All right, we will see everybody 9 o'clock Monday morning. Stay safe this weekend. Have a good weekend. Thank you.
All right, court is adjourned. I thought we might hear motions, but nobody had any to make this afternoon. We're going to take a quick break and reboot and talk about both of these cases coming up here on Court TV Live.
Hi, folks. Joe Namath here to alert you to an important Medicare deadline. You may be able to get Part C benefits, including prescriptions, transportation, meals, and coverage for dental work with extractions, fillings, even dentures, all at no additional cost. Plus, depending on your zip code, the benefit that adds money to your Social Security check every single month. Call to check your zip code and get what you deserve. It's free.
I call to save money on copays and get prescriptions, transportation, and my dental work covered.
I couldn't believe I was spending money I don't have to spend.
I'm on a fixed income, so I called to get money added to my Social Security check.
Before the Medicare open enrollment deadline, you may be able to get extra benefits and get money added to your Social Security check every single month. It's simple. 1, call the number on your screen. 2, the live agent will check your zip code to see if you're able to eliminate co-pays and get prescriptions, transportation, meals, and expanded coverage for dental work with extractions, fillings, even dentures, all at no additional cost. And 3, they'll check if you're eligible to get benefits that add money to your Social Security check every single month, up to $1,700 a year. Call to check your zip code and don't miss the deadline.
I called to eliminate co-pays.
I called to check my zip code.
I called to get everything I deserve.
I called to get money added to my Social Security check.
Millions of people have trusted the Medicare coverage helpline. You can too. Call the 800 number on your screen to check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-778-7100. That's 1-800-778-7100 now.
Hi, Jimmy J.J. Walker here. If you're on Medicare, listen to this. It's the Medicare annual enrollment period, and there's a deadline to update your coverage and benefits for all of next year. I didn't want to miss out, so I called the 1-800 number to see what Part C benefits I could get. An actual person answered and looked up my zip code, and boom! I was offered extra benefits like dental care with extractions, fillings, dentures, transportation, and so much more. All at no additional cost. And get this, based on my zip code, I can get $100 a month. That's $1,200 a year added to my Social Security check. I was like, dynamite! Call, check your zip code.
I called, and he looked up my zip code and said I could eliminate co-pays and get expanded dental care, prescriptions, transportation, and meals covered at no extra cost.
I couldn't believe my zip code has a benefit that adds money to my Social Security check. They help me so much.
It's simple. 1, call the number on the screen. 2, the agent will check your zip code to see if you're able to eliminate co-pays, get expanded dental coverage, prescriptions, transportation, and meals. And 3, they will check to see if you're eligible for the benefit that adds money to your Social Security check every month, up to $1,700 a year. Call to check your zip code and get what you deserve.
I called to check my zip code.
I called to eliminate co-pays.
I called to save money.
I called to get my dental work covered.
I called to get money added to my Social Security check.
Call, check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-989-5137. That's 1-800-989-5137 now.
Welcome back. We're going to go back to the state of Wisconsin versus Kyle Rittenhouse. The prosecutors are asking for jurors to consider lesser charges on the counts involving the shootings of Anthony Huber and Gage Grosskreutz. This move would lower the proof needed for conviction. Take a listen as the Assistant District Attorney James Krause asked for lesser included yesterday.
I'm not sure if we finalized our request. Certainly on count 3 and 4, I think we can discuss on other counts, but the first-degree homicide, first-degree intentional homicide, we will ask for all lesser included. The attempted homicide to Gage Grosskreutz, we would ask for I think there's only one lesser included. We are not inclined to ask for lesser included on the reckless endangering safety charges. At this moment, we're not inclined to ask for lesser included on count 1 to Mr. Rosenbaum, but I think we need to discuss that more fully.
Okay.
Still with us, former homicide prosecutor Melba Pearson and former criminal defense attorney who represented Jodi Arias, Kirk Nurmi. All right, let me start with you, Melba, if I could. The first thing I want to do is look at the counts and what the lessers are. So you can see on your screen, count 1, the first-degree reckless homicide, and this is regarding the victim, Joseph Rosenbaum. No lessers on that one. Now, on count 2, however, this is the first-degree recklessly endangering safety, and this is regarding Richie McGinnis. This one does have a lesser of second-degree reckless endangerment. Describe for us, Melba, if you would, the benefit to including lessers, and really, in my mind, why in the world would the state not ask for lesser-included offenses?
Yeah, I'm a firm believer in lesser included offenses from the standpoint is that it almost gives the jury a menu from which to select from, right? So when you go into closing arguments, you can say, listen, if you feel that the state did not meet our burden, then obviously the verdict should be not guilty. If you feel that we've met our burden, but maybe not quite for the top charge, well, here's a nice compromise for you. Here's, reckless endangerment. And then if you think we've proven everything, then you argue for the top charge. But regardless, you're still arguing for the top charge, but you're giving the jury an out just in case they have some questions or didn't feel 100% confident in voting guilty for the top charge. It's a way to make sure that you get something out of this as opposed to all or nothing and then ending up walking away with a not guilty verdict.
And I really feel like the state initially had kind of indicated perhaps they would not ask for the lesser included, and then I think at the conclusion of all of the evidence determined they did want to ask for that. All right, Kirk, let's look together at the second degree, rather count 3 is what we're on. The first degree recklessly endangering the safety of the jump kick man, as he was known. There are no lesser charges available on that one. However, on count 4, first-degree intentional homicide, and again, the victim in that case is Anthony Huber. The lesser of that is the second-degree intentional homicide. So, in the first-degree reckless homicide is another lesser of that. Kirk, tell me your thoughts around, is there any way, in your experience, that a defense attorney can object to lesser included being part of the charges to the jury?
Not really, and it might not be well advised of a defense attorney, but this could be a rare exception to do that because you always want to try to mitigate the damage. Typically, it is the defense. Implicit in your question is the idea that it's us defense attorneys that are typically doing that, right? So, the state, I think, is well advised seeking these in all these cases, as Melba said, because they need to find that middle ground because the grandiose evidence that they said they were going to present really didn't come to pass. And so they are going to need to focus that jury on more reasonable reaction to what Mr. Rittenhouse did, finding that middle ground and salvaging a conviction out of what might otherwise be an acquittal because of the charges being so high.
Right. Let's look at the counts 5 and 6 and the lessers included. Melba, I've got a good question for you about these. Count 5 is the attempt of first-degree intentional homicide. Again, the surviving victim, Gage Grosskreutz. The lesser of that is the second-degree intentional homicide, and as well as the first-degree reckless endangerment. Then on count 6, which was the possession of a dangerous weapon by a person under 18, that one stands as is. All right, Melba, let me ask you this. This took 3 screens for us to show you just the charges, the names of them, and the lessers. We know when the jury goes out to deliberate, they have the law, and then they have to determine what facts they find to be true and apply those to the law. How confusing does it become to a jury, if it does at all in your experience, to add this many counts that they literally have to go through and determine what, if anything, they find the defendant guilty of?
It can be confusing, but that's why it's very important that you lay out your closing argument with razor sharp precision. This is where you may want to employ the use of technology. So you bring out a PowerPoint, and much like we went through it screen by screen, you go through each charge and the element screen by screen so that the jury understands what each of the charges involve, what needs to be proven, and then you discuss which facts would apply to each of the different elements to show that you've met your burden. Juries have encountered, indictments that are pages long when you think about your conspiracy cases, your racketeering, your mob style cases, right? Many of those will have 20 and 30 count indictments that the jury has to sift through. So it's not unusual to have so many charges on the table. The key is just to make sure that you're very methodical in the way that you explain everyone. You've got to, play teacher. Make sure that you're not speaking over the jury's heads. Make it very simple. Use common examples that people can get their minds around and understand. I'm not saying dumb it down, but you have to make sure that it's accessible to everyone so that the jury can take that back with them and understand what they need to think through as they're deliberating and coming to a verdict.
And you made a really good point. Demonstrative aids, that's something. Raise your hand, both of you, if you don't see those used as often as they should be. I know as a judge when I was on the bench, so many opportunities during opening and closing to use those demonstrative aids to put it in little nuggets for the jury to really be able to understand. All right, thank you so much, Melba Pearson, for joining us today. I greatly appreciate all of your expert analysis. Stick around, Kirk. You're going to be with us next hour. We're going to continue our live coverage of two major trials.
You're listening to the smooth sounds of 90.5 FM.
As well as the three defendants charged in Georgia in the killing of AHUMAD Arbery.
Online 365.
Travis and Gregory McMichael are charged along with their neighbor William Wright.
You're listening to the smooth sounds of 90.5 FM. WJSJBC Radio.
It's in this case.
365.
Will be revealed where all facts that matter are revealed.
Tune in
In a courtroom.
to the Rob G. Afternoon Drive Show. Hey, this is your girl Cotton.
Every year, almost 30,000 babies in America are born with birth injuries such as cerebral palsy and brain damage. As a dad of two beautiful boys myself, it's every parent's worst nightmare. What you may not know is that too often, medical negligence may have caused your baby's brain damage, no matter what the doctor or hospital says. That's why we believe that every child born with brain damage deserves a chance to have their file looked at by our firm for free. Our dedicated staff of nurses, medical reviewers, and attorneys are standing by to take your call. And having represented parents just like you, we work with your family to determine if and how much compensation you deserve. As America's largest injury firm, we've recovered billions for our clients. And you can even sign up with our firm from the comfort of your home. If your child was born with brain damage, please call us to receive a free birth injury lawsuit brochure and learn more about how we can help. There's only one Morgan & Morgan for the people.
Call 844-400-9515. If you, like many people, are covered by both Medicare and your state's Medicaid, here's something important to know. Medicare annual enrollment is here and ends December 7th. So now's a great time to look at a United Healthcare Dual Complete plan. It could give you even more health benefits than you already have. To find out if you or someone you care about is eligible, it's easy. Call now to talk with us. We can explain it all and answer your questions. Medicaid gives you benefits, and Medicare gives you some too. But a dual complete plan can add even more benefits and features compared to original Medicare. You'll get $0 copays on all covered prescriptions, including brand names. And depending on where you live, you could enjoy other benefits too, like more dental care and rides to and from your doctor or pharmacy. Most plans even give you up to $150 a month on a prepaid card for covered over-the-counter products and groceries. And best of all, with this plan, there's no extra cost to you. Remember, if you have Medicare and Medicaid, chances are you could get a dual complete plan. So call now to talk with us. Our agents are available to help. We know healthcare can be confusing. United Healthcare can straighten things out. And with over 40 years of experience, you can count on us to be there for you. With a dual complete plan, you could have $0 copays on all covered prescriptions, a prepaid card for covered over-the-counter products and groceries, more dental coverage too, all at no extra cost. If you have both Medicare and Medicaid, you may be eligible for dual complete. Hurry, annual enrollment ends December 7th, so call the number on your screen now to see if you're eligible or to enroll. There's more for you with the United Healthcare Dual Complete Plan.
That's a car, and this is Drive Time. We make getting approved to get a car easy.
Oh, I love easy things.
Do you need a car?
Big time.
Well, with Drive Time, you have a 99% chance of getting approved, and it only takes 2 minutes. So, grab your phone.
You got it.
Go to drivetime.com.
Uh-huh.
Fill out some basic info.
Check.
And
I got approved. That was easy.
Super easy.
Easy.
Go to drivetime.com and shop thousands of available cars now. You can see vehicle photos, history reports, features, and see your real down payment all on your phone. Easy.
Welcome back to Court TV Live. I'm Ashley Wilcott. Good Friday afternoon to you. Court TV camera.